to decide what is the law and how to apply it to an individual case. Note this next bit. It provides at least some certainty. Not complete and utter certainty, but as much certainty as we can possibly get. Because it would only provide complete certainty if rules never changed. Yes, that would follow, wouldn't it? If there is always a possibility that rules might change because there's a need for the House of Lords to be flexible, then the best is that we could say is it provides as much certainty as we can possibly get at within the context of the law. It provides at least some certainty on which people can rely, i.e. people are relying on a clear statement of the law, as well as the basis for the development of legal rules. So it obviously not only relates to us, to Joe and Josephine Public, and the way in which we act on our legal duties, our legal obligations, our rights, etc., but it also relates technically to the development of the law, because that's the two sides of precedent. It's clearly providing rules that regulate the social world, but we're also concerned with its internal logic, with the development of legal doctrine. Next sentence, I think, is very important. The Lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law. Well, it's going back on what Lord Halsbury's saying, isn't it? It's a critique, it's an argument against Lord Halsbury. Undue reliance on rigidity means that injustice in particular cases might arise. Because if justice requires authority, justice also requires flexibility, a response to the facts of an individual case that may disturb or cause a perturbation within the doctrine of precedent. Justice, and this is perhaps a philosophical point about justice, justice needs to be responsive. Justice needs to respond to the call to be just as much as justice requires authoritative propositions. There's always this tension then. This tension will remain within precedent, it won't be resolved. But I think that's an interesting way to kind of take us through both Lord Denning's campaign in the Court of Appeal and, if you acknowledge a relationship between human rights and justice, something to do with the way in which the impact of Strasbourg jurisprudence is having an effect not just on the development of common law, clearly it is, but also on the doctrine of precedent. This takes us then to, if you like, a technical point. In the wake of the 66 statement, the judges, the lordships, law lords resolved to modify the way they approach precedent. They say we will consider ourselves normally, it's a bit vague because they want to leave themselves room for manoeuvre, we will consider ourselves, this is the judges speaking, normally bound by our previous decisions. But in certain cases, we will depart from them when it is right to do so. Now, what does that mean? When it is right to do so. Have a look at the 66